Good morning. I'm really pleased to be here. And I want to thank Ellen Maris and Laura Oren especially for organizing this groundbreaking conference. As someone who's been straddling and perhaps juggling feminist jurisprudence and children's jurisprudence for years, this opportunity to consider them together with some of the best minds on the subject is a real treat. I'm actually hoping to leave some time for questions, but we'll see. Excuse me, I woke up with a cold this morning. What I want to do with this paper is to bring some of feminist jurisprudence methods to child-centered jurisprudence to help us move forward, I hope, to a more critical and comprehensive perspective regarding justice centered around children. A theme I'm seeing is in this conference. Feminist jurisprudence has examined how law constructs gender. The project has been, in essence, to politicize women. That is, to denaturalize womanhood, to take women out of the private realm, to situate women in the market and the polity, to show that families are not pre-political, and to remove children from dependency on fathers and husbands, and free women from dependency that arises out of caregiving, and in essence, to view women as moral agents. Now, child-centered jurisprudence has traveled a different path. It has largely assumed the naturalness of children, childhood, and dependency. It has not looked systematically at the legal construction of childhood. It has not fundamentally interrogated dependency. And it has not engaged extensively with the political role of childhood. Instead, child-centered jurisprudence is focused primarily on children's dependency and vulnerability. That is, focuses on relationships between children and parents, children in the state, and children in the educational systems. As a result, we have a child-centered jurisprudence that is largely unconcerned with the political nature and purpose of childhood. And instead, this jurisprudence assumes dependency and privacy as a given. So unlike women at the center of the feminist jurisprudence, who is a complex, multifaceted, and autonomous human being, the child at the center of children's jurisprudence is a developing being in need of protection and education during a legally and cognitively defined period of childhood. Now, I want to push child-centered jurisprudence to be more robust. So just as feminism has revealed the roles, contours, and possibilities of gender, dependency, privacy, and autonomy, my paper seeks to illustrate the political roles of childhood, dependency, privacy, and autonomy, and hoping that this project might lead us to a broader and deeper child-centered jurisprudence that breaks out of a narrow focus on dependency and vulnerability, and both appreciates and bolsters the public role of childhood and its deep connections to adulthood, both to the adults who support children and through the adults that children will become. My hypothesis is that this intergenerational and politicized child-centered jurisprudence will inure to the benefit of women who continue, despite many advances, to be intimately and deeply connected to and bound by dependency. So first I'll say a few words about child-centered jurisprudence as I see it, a jurisprudence that is bounded by dependency, vulnerability, and is somewhat static. Then I'm going to explore how difficult it is to think about children in any way but vulnerable and dependent and private. Which is to say, basically, that I will explore the deep and broad roles of the construction of childhood as a discrete, dependent, and private place play in our political system, and I will trace a series of historical events that help lead to this privatization of dependency. With that in mind, I'll conclude with a sketch of what it might mean to think about children outside of their dependent states as future adults also, and how that might help us reframe childhood even and especially in a liberal democratic system. So I'm not trying to get out of this system, even while we're here in the structure that we have. I want to focus on how we can think differently, how we can actually behave differently as a policy matter. Okay, so child-centered jurisprudence is generally concerned with children's rights and children's representation. The former, children's rights, generally is concerned with children's right, includes two different types of rights. What I call quasi-civil rights and dependency rights. The quasi-civil rights are very much like adult civil rights, but they may be cabined by children's youth And they include the rights to be free from coercive state intervention, to have equal treatment among dependents, to procedural due process, and to modified versions of the constitutionally guaranteed substantive freedoms that adults enjoy, where, though children's dependency and vulnerability are often circumscribed the full extent of constitutional freedom, as in Casey, for example, or their dependency and vulnerability frees them from the full responsibility of their actions, as in Roper. Now, dependency rights are also centered on the child and dependency, but they are concerned with the protection and socialization of children. These rights apply to what parents in the state owe the children as dependents who must be cared for and reared to adulthood. Hence, they govern adult care of children regarding custody, control, education, basic sustenance, and physical and medical care. And although dependency rights promote children's long-term freedom and interests as adults, arguably, they are not geared to emancipating children as children. Child-centered jurisprudence also examines how children are represented before the law. For example, who represents children and what role do they play in this representation? Here, the primary debates are whether children determine the objectives of the representation or whether children's best interests guide the representation. And these debates, too, are centered on children's vulnerability and dependence. In these ways, then, child-centered jurisprudence, while extraordinarily important, sorry, I exposed myself, does not really get to the questions of children's dependency. It takes dependency as a given, and does not get beyond dependency. It's constrained to and by dependency, and does not question the fundamental construct of dependency. So that child-centered jurisprudence does not challenge the legal norm that children are raised in families, or the fact that public investment in children, that is in education, in parks, transportation, health, these public goods are essentially centered around the children's caregivers and privatized. Now, this privatized, dependent, and vulnerable child is, of course, a social construct. And of course, during much of children's lives, or children's childhood that is, children are vulnerable and even dependent. That much may be inevitable, that is to say natural, but it is the length and contours of this vulnerability that we have crafted. So it is to both the particular construction of children as dependents in private space and to the centrality of this construction to our political and perhaps social order that I want to turn to now and spend some time on. Now, I and many in this room have observed the political functions of child-centered jurisprudence and the moral currents that children carry from their families and as future democratic citizens. And indeed, the instrumental moral functions of the political child have worked fairly well, at least in my estimation. But other aspects of this privatized dependency have been less successful and are all but invisible. Holly Brewer's work has highlighted the centrality of childhood itself to our political regime. For the separation of children from the polity as an ideological matter was integral to the social contract that created the United States, i.e. the United States Constitution, which was, and perhaps still is, remarkable for its basis on the consent of those whom it governs. Just won't even critique that, but we know. In theory, it was based on it. Okay. That's another topic, sort of. Now, the roots of childhood is a separate status, and one that is in contrast to adulthood and moral agencies are grounded in the epistemological, moral, and political philosophy of the Enlightenment and the rationalist empiricist thinking that informed it. And these intellectual movements centered on notions that people had the intellectual capacity and knowledge to find or at least explain meaning in rational rather than solely faith-based or defined terms. This turn toward the individual as a source of knowledge and understanding reached through rational or empirical processes underscores the connection between agency and childhood. Now, agency and adulthood, a time when abstract thinking is normally at its height, and of course this connects agency from childhood. Now, this humanization and individuation of capacity for wisdom set the stage for a movement away from central